when it comes to the books and records of an association, whether it's a condo or a homeowners association, we need to divide the world into two categories, and hopefully one category is very small, and that's the unincorporated association category. If you remember last week, we discussed, and hopefully I said several times, you don't ever want to be a member of an unincorporated association, definitely never serve on the board of an unincorporated association. So hopefully that world is very small. If you are an incorporated association, then remember we talked about there are certain default provisions under Oklahoma statute that the corporation falls under, and we talked about those UOP, unless otherwise provided categories, that supplies us information on quorum, whether it's a plurality voting system or otherwise. So if you're incorporated, the law supplies some information for us, and that also includes records requests. And so this 18 OS, if you remember, is Title 18. OS stands for Oklahoma Statutes, and 1065 is the Corporate Records Statute. It's not, and if you go to this and look, it's not going to explain to you exactly what records you're supposed to keep. It's not going to tell you how long you're supposed to keep them. It's not going to tell you necessarily in what form you can keep them. Actually, if you go look at section 1069, that will answer a little bit of that, but not as much as probably you're wanting. But basically, the books and records of the association are whatever documents, electronic or otherwise, that the association keeps. So it's going to be permanent documents like the meeting minutes. We have to keep meeting minutes. There's no expiration date. You always keep them because that's the history of what has gone on. You might keep tax returns for 7 years. You might keep financials, bank statements, insurance policies, contracts. The board may archive their emails knowingly or unwittingly. If the board sets up a board at yahoo.com, and that yahoo.com email is a forwarding address, which is, by the way, is a great way to set it up, more than likely your emails are being archived. So whatever is sent to or from the board's email address, then that ostensibly is a record of the association. Okay? So now, and I may have mentioned this last week, where this usually comes up is in a couple of categories. The largest category is someone has been told no, they're throwing an adult temper tantrum, and they are going to make everyone's life around them, to the extent they can, a living hell. And the easiest way to do that as a homeowner association member is to make a records request. It is probably the broadest right that a unit or a lot owner has. And it's very expensive because the answer from the association can't be no unless they're asking for something that is privileged, which is very, very narrow, very small. So for the most part, when a records request comes in, it can't be no, it has to be not yet, or here's when you can have it, or let's make these available at a mutually convenient time. So usually it's somebody trying to make others jump through hoops. Another small category would be someone is new to the neighborhood, the addition, and they want to familiarize themselves with the books and records and get to know the manager and all of that. They're genuinely interested. It's probably a small category. And then the next small category is someone legitimately needs a record or wants a record, copy of the insurance policy for their insurer. Maybe they need a copy of the covenants, conditions, and restrictions, or the bylaws or something. Records requests are an opportunity most of the time for the association board to provide good customer service. And what I'm talking about is, we all know, because we went to the class last week, that the covenants are filed of record. They're available to anybody. And it is a technically accurate and right, as in right versus incorrect, response for the association to tell someone who's asking for a copy of the covenants, well, they're online or they're available to you, you can go get them yourself. And as a younger lawyer, that's exactly what I would tell other lawyers. If they asked me for a copy of my client, which is the association's covenants, my response was, go find them yourself. Why should I do the work for you? I don't have any obligation to do other attorneys' research for them. I answer that question differently now and encourage my association clients to answer their constituents or their members differently as well. So typically, the best way to provide for the books and records is putting them online. So you can streamline this process by either having an open portal, meaning you don't need any kind of login, they're just available. If anybody can find the website, they can look at them. Having all the books and records to the extent it makes sense to do so and there's no Financial Privacy Act issue, then you just put them online. And then it might be an appropriate response when someone asks, hey, I need a P&L, I need a copy of the insurance policy, I need a copy of the covenants well, we've got all of that conveniently online, here's the link. Right? And they can go satisfy themselves. It also shifts the printing costs from the association, postage costs. There are plenty of services out there where you can put the association's bank statement online. Probably don't want to make that available just to the general public. I had an association, and mercifully they were represented by one of my closest law school friends. And by the time he got into the case, they had already taken the position that they could not provide a copy of the association's bank statement because my client wasn't entitled to know the bank account number. And my response was, so how do you navigate writing checks to third parties? Because it has the bank account number on each and every check, doesn't it? And my friend moved them off of that asinine position pretty quickly. But sometimes associations, when they don't like, whether it's my client or somebody else, they take weird positions. But the answer is not no. Do they get a copy of the bank statement? They get a copy of the bank statement, just like they get a copy of everything else except confidential attorney-client communications, possibly Financial Privacy Act. Now, they may not be able to get a copy of an individual member's check, right? If there's sensitive employment information, dates of birth, social security numbers, things like that, that might be off limits. But the general books and records of the association are fair game. Yes, sir?
What about a homeowner's name, their email address and phone number? Could that be considered confidential? Are you required to share that with everyone in your neighborhood?
So, we don't have a whole lot of guidance. In fact, we have no guidance in terms of answering that exact question. And so with that disclaimer, I could be flat out wrong on this, but this is the position I take. So the name and the address, and in fact,
I guess it is public record.
If you go back and look at 1065 and 1069, it'll talk about the shareholders list. And in this context, when it says shareholder, it's talking about the member, nonprofit member. So providing the name and the address, I think the association has to provide that. Now, information beyond that, ages, dates of birth, email addresses, I don't believe the association has to provide that.
And phone numbers also.
And phone numbers. That's the position that I take. Now, it's entirely possible if that gets litigated, a judge will say, no, you have to provide it. But at that point, you have a judge ordering you to provide it. So now my board members have protection.